I ask them how to go about it. And what does judge shopping mean? We all sort of know what it means, but it doesn't mean to lie. I don't want you to think that. But yeah, I got the feeling, like, why do you care? And you know what I mean? Like, you just said to me, you have somebody wants to continue. You know, if you had a hint that he or she was judge shopping, you want to make sure that he or she is in your session. Like, who cares? Why are you so, you're in the session 2-3 months, like, who cares? So even if the judge says, oh, I don't like going in front of Cowin, he's not going to tell you that, but like, you sort of get, you're going to lose sleep? Like, why do you care? Like, I know I wouldn't care. He doesn't like me. She doesn't like me. Why is that so important that you'd want him in the session? That's what, like, why?
I think if we expect that the practitioners are going to uphold the law, we need to, judges need to do what they can to make sure that they do, and not just say, I have a hint that they're doing this for the wrong reason, and it is
Not the hint, but you're not sure.
And,
So
that's why,
give the lawyer the benefit of the doubt. You got a hint, suspicion, you're not sure. You know what? He wants a continuance in May. I'm out of the session in May. Who cares? As opposed to, no, we'll make it the last week of April. Because you're not really going to know. It's not going to say, I don't want, you know, like, who cares? It doesn't bother. I wouldn't, like, if I was a judge, believe me, I never want to be a judge. Wouldn't, like, who cares? He thinks I'm too tough or too easy. Who cares?
it would bother me.
Really?
Yes.
Okay, let's go this way then. What about continuances? What's your viewpoint on continuances?
Look, if somebody has, people are busy, things happen, people are out of town, witnesses are out of town. If people have been working the case, they haven't been ignoring the case, and they just need more time, then yes, I'm okay with continuances. And there was a mention of this in my application.
Yes.
What I didn't like to see in my practice was, again, the tracking order for average cases was 24 months, was a attorney on the other side doing nothing for 24 months. And then when the notice of the pretrial conference comes out, call me up and say, I got some depositions to do, so I'm going to ask for an enlargement. He hadn't been doing anything for 2 years.
Yeah.
That's.
I get that, but now both sides are doing everything in the case.
Yeah.
Okay, now the case is on for trial, April 20th. April 10th, I want a continuance, I got a matter somewhere else.
I asked what the matter is.
I got another case.
Another trial.
Yes.
Well, then I'd ask which trial was scheduled first.
Okay.
The one that takes first, takes precedence.
Okay. So I'll say the case with you, Judge, but mine is a federal case because that's scheduled after.
The second one is a federal case.
Yes, and I want a continuance, Judge.
I do two things because I practice in federal court as well.
Yes.
And I would say, look, I advise you to inform the federal judge that this case was scheduled first. Now, having been in front of federal judges, that may not, right, and that's why I would also say, do that. If you get denied there, tell me and I will change this trial date.
Okay.
I'm
going to make it even more specific. I have a case with you April 20th, April 10th, I come before, I need a continuance. I have a Social Security disability case in Arkansas. What are you doing? And just to give you a hint, they do not continue cases. If you miss that case in Arkansas, because you may not do Social Security, you're waiting another 8 months, 9 months, maybe a year. What do you do in that case?
I would ask you, when was the Arkansas case scheduled compared to when the trial here was scheduled? And if the trial was scheduled after Arkansas, why didn't you move for continuance earlier? More than 10 days before the trial.
Okay, so I notified you 30 days before because I just found out.
All right, that changes the calculus.
Okay.
As you get further back, there's more flexibility. Not the other side hasn't already put their witnesses on notice and gotten people here. So as the attorney is making more of an effort to keep the system going in a fluid manner, I would get more flexible.
I get the impression, this is just me, I get the strong impression that, again, in my hypothetical, these are questions I ask everybody, by the way, and with all due respect, you've got a phenomenal background. I can't tell you anyone who's been so I don't know what the word is, more stringent or whatever on these continuances and judge shopping. And I've been here a long time, okay? I got the impression on this one, that again, you'd say, okay, I'm in the session here, May 3rd. If it was April 20th, like, again, what, who cares? I almost feel like you're so like, you know what, I'm not, this guy may have a Social Security case September 20th in Arkansas, okay, September, a week later. Who cares? Nobody does that. I'm gonna be right up front with you. I have a national Social Security disability law firm, okay? We have cases, thousands of cases in every state in the country. We ask for continuances a lot because we're all over the place. You'd be a really tough case judge in those cases. Like, he is, yeah, and you cannot just, if someone else ever comes before you, you cannot continue a Social Security disability law case. You cannot. You can't even, not a chance. And if that client, I don't know how compassionate you are, but if that individual doesn't have their case, it could be another year. And I don't know if you know this, but they've probably already been waiting over 2 years without benefits. Some of these people are sleeping under bridges. Some people are homeless. So again, when it comes to Social Security cases, and I know, I don't think you've handled many, you've handled any. You've got to really, I don't know how compassionate you are, but you cannot continue with Social Security case. These people, I mean, we have so many sad stories. People on the verge of suicide. You can't continue a Social Security case. It's just the cases. I mean, they're so off. They're off. It's sad.
I just responded to the who cares question, and I appreciate you telling me that about the Social Security, and I would expect the attorney who's asking for the continuance to tell me that, so that I know, because I do everything through a lens of reasonableness. I like to think I do. But in response to your question, who cares? The other side. If the other side is like, you know what, I'm not ready to go to trial either, and I could really use a continuance, then I'm going to be a lot more agreeable. But if the other side is like, I have people coming in from out of town, you know, why didn't I know this? The other side.
I got that. But let's go my hypothetical. Unbelievable. Other side doesn't care. Prosecutor in a criminal case doesn't care. Don't worry about the officer. He'll show up. Civil case, don't worry. I got my witnesses. They don't care. Well, you care. So they don't care. Now let's make it easy. Now it's the second time. Okay? Now, unbelievable. You continue it. You're in a good mood today. You continue it to June 15th. Unbelievable. Now we got a case in Texas. And both sides, everyone says no problem. We'll continue it again.
If I have another trial on for that day, I'd probably say yes, because it's not affecting the system and it's not affecting either party.
Okay. Now it's the third time. And by the way, these things happen. I mean, and there's only like 1 or 2. These things happen, sir. I mean, you know. Now the third time. Unbelievable. My wife just surprised me with my anniversary. And she surprised me, and I did just, all these, what I'm telling you are real stories, by the way. I'm not making these up. Taking me to Bermuda. Taking me to Bermuda. Our 25th, again, this didn't happen to me. These are stories from other people. 25th wedding anniversary. 3rd continuance. Other side doesn't care. Like, what do you care? What are you doing?
At this point, I am not happy. I think that the lawyer takes the case needs to be tried. There's now a 3rd trial date. The wife knows that her husband is an attorney, and maybe should have.
You want to surprise them? Ever been surprised?
Surprises are sometimes a very bad thing. Surprises are always a bad thing in the legal profession. If there are unrefundable plane tickets involved.
So they're refundable.
They're
refundable.
I have a hard time.
Really? So that vacation in Bermuda, okay? Sonesta Beach Club, overlooking the water. She told me like 4 or 5 days ago, told her sisters, everyone, and they're refundable tickets. You're gonna say, you know what, can't make it. And then you have to go a different part of the year maybe, because both of them have plans, you know, the camp for the kids, and maybe we'll have to go in the fall. Maybe the weather won't be as great, but you know what, the third time on, and I know everybody said, okay, the continuance, but you know what? Screw Bermuda. I want you to try the case. I got it. Let me ask this question. I'm going to tell you a story. I usually don't tell this story. Again, I probably go to court twice in 25 years. I don't go to court. I manage my operation. But when I had a law school, I did a lot of criminal work. I was in probably 3 courts at the same time. All of it. I was busy eating my sandwich in the car. Okay, so I was in the BMC. The early, oh God, 40 years ago maybe, a long time ago. I was at Roxbury that day, but I know I had to go back to the BMC. I'm back to the BMC, and the judge, and I got there at like 11 o'clock. I can only imagine what you do in this situation. That judge said to me, Mr. Rockefeller, this court starts at 9. Judge, with all due respect, I was in Roxbury and then I have to go there in Chelsea. I called the court, but I couldn't get through to anyone. You know what? This court starts at 9. You're in the dock or you're paying a $100 fine forthwith. Judge, I don't have $100. Can I go ask my father? My father died 30 years ago. It was a long time ago. Go back to my father. He was at City Hall. Yeah, who the hell is this? It doesn't matter. You got $100. You go to the bank. $100 is a lot to have in your pocket. Gave you the $100. Well, make a long story short, I've been on the council a long time. 2 years later, I ran for governor's council and won. Okay? And that judge in the district court applied to the Superior Court. Okay? It is a true story. And it was a snowy day. Okay? And he was supposed to meet me in my office. A lot of us meeting before him. I said, Judge, he calls me up. I said, oh, yeah, I go, give me a break. It's snowing. Forget it. We'll set another appointment. Okay? We did. Had a nice meeting with him. Man, make a long story short, I chaired the hearing, voted for the person. He went through 8-0. And he says it was one of the biggest mistakes of my life. I never should have been so rigid, so this, so that. And it's sort of the end of the story, but like, whoa, you gotta be a little, vacation, Bermuda? I don't care where it is. It's my daughter's graduation. Well, I didn't realize it then. I didn't know. I don't know. You're going to say, why the hell didn't you know about it? But things come up. And I guess my question is like, who cares? You're going to get in trouble? I doubt it. Both sides, nobody disagrees. They're all says, have the continuance. So you know where I'm from on these. I have personal experience in these types of cases. I hear stories from other lawyers. It's a very, very, very minor problem. Kennedy, I, and Juneville, we always talk about one specific judge, a pain in the neck, but overall, it's not an issue. But I can tell you, you're phenomenal background. You have a wonderful family, okay? But I've never had in all my years someone so, and you want me to be upfront, so rigid and so like, of all the years that I've been here, and these are questions that I ask all the time. It's not like I'm picking on you. And I get it. The cop's there. Even I get it. The witnesses are there. I'm not talking about those cases. I'm talking about when nobody cares. Unfortunately, whatever. But I hope you just think about that a little. The other thing too, your law firm, how many lawyers?
44.
That's a lot of lawyers.
They're not all working on one case.
They're not all working on one case. But you know what? Juvenile. he works for himself. Kennedy, by himself. I believe all the people in this room except me, I have multiple lawyers. Most of them have maybe one or very few lawyers, if any, other than themselves. So remember, they can't go to someone and say the way you could. Oh, I know you got a million cases. Do me a favor. My husband just surprised me. I got a trip. Can you handle this motion next week? Most of these other lawyers can't. You got 44 lawyers. Nobody's got two. Probably no one's got two lawyers here. So think of those people. It's not like you're going against another law firm. Ropes. Yeah, get someone else. There's so many solo practitioners out there. And you know what else, Joe? There's a lot of people out there. It's tough out there. I've been so lucky and fortunate. But you know what? With all due respect to you, it's tough to pay the rent. It's tough to pay the secretary, the electric bill. And you know what? There may be that person who comes in front of you with a criminal case. And guess what? The defendant didn't pay it. You may say, well, that's not your problem. But you know what? This guy has to support his family. And he doesn't make that much difference if you continue the case for 2 months. He's not going to tell you, I haven't got paid. Yeah, he may tell you, my witness, Mr. Green, somehow, some way, you got to figure this guy for survival. No one is as fortunate as you working for a big law firm. K&P, 40 some odd lawyers. This guy may be struggling. He's got his kid's college, his kid's high school bill, whatever it is. So I'm a big fan of continuances. Imagine if that lawyer had to appear in front of you on a criminal case and he never got paid. How would you feel? Seriously, on that, I'm almost done. How would you feel if you found out later on that he never got paid in that case because you wouldn't grant him a 30-day continuance? Somehow you found that out. How would you feel?
Mike, I'm sorry to respond to your question, but he didn't get paid because he didn't get a continuance?
No, he didn't get paid. Exactly. The defendant didn't pay him, hadn't paid him yet. Okay? Maybe he's been only, whatever, he didn't pay him yet. And he believed, I'm not going to tell you, but maybe if another 30 days, the defendant's cousin and aunt would have come up with some money. It happens all the time. You can ask these guys. It happens a lot. Not like you go into someone, okay, here's 3,000, 2,000. Sometimes, okay, I'm charging you 4,000 to give you 1,000. Very few lawyers who work for themselves are going to say no to the $1,000. And then I'll give you another 1,000, another 1,000. But, yeah, the trial's on tomorrow. But you know what? Oh, can you get a continuance? I promise you, attorney so-and-so, I'll have the check for you in a week. That's what happens every single day. So I'm asking you, if you eventually found out that lawyer didn't get paid, and he asked for continuance, how would you feel?
I feel bad whenever a lawyer has done his or her best and doesn't get paid.
I'm sorry, can't hear you.
Sorry. Anytime a lawyer does his or her best to represent the client and doesn't get paid, I feel bad.
Do you feel like maybe the next time you'd be a little lenient, especially, I don't do criminal, at least on criminal cases, when a defense attorney's asking, I got a case here, maybe he can't tell you I didn't get paid. He can't tell you that. But remember, that happens a lot. A lot. We're not talking big drug dealers. Yeah, they got plenty of money. I'm talking the guy who got pulled over for operating under. Maybe he or she doesn't have a lot of money. They're asking for a continuance without telling you they didn't get paid. You're not going to know that. But I'm getting the feeling from you, you're probably not going to give him a continuance. And these guys, it happens to them all the time. These are not just my stories. I don't know if they're going to mention it today, but this happens a lot. 95% of judges, there's no problem with continuances. Second, third time, maybe. But
I think you have unfairly cast me as more rigid than I am.
oh, that's good. Thank you. No, I'm serious.
So, I would consider requests with an eye towards being reasonable. But the lawyers have to be reasonable too in terms of moving the cases towards resolution.
The last thing, I won't continue, it's hard for these lawyers to be reasonable when they didn't get paid. They have to, they got to be a little creative. They can't say they didn't get paid. They can't say in front of you, I didn't get paid. It's not a real, you got it. Don't have any more questions. I feel good that at least told you some of these stories. It probably won't make an effect, but you never know. Maybe a slight thing down the road, you'll hear that. But I didn't think I was going to be more than 2 or 3 minutes. I'm way over than I thought I'd say. But it's good to see your family here. And again, best of luck.
Thank you very much.
Thank you.
Thank you. Thank you. I appreciate the time that we spent chatting a couple of times. From a different perspective, it's great about law firm. It's the good, the bad, and the ugly for a year. And hopefully a less ugly. By ugly, I mean mainly temperaments, you know. I have this clause about you saying that you've done great. I read the letter from SJC, Justice Scott Campbell, as well. That's a heart. But to counsel Ionel's point about cops, because with the cops were as a police chief, I was a police chief for 9 years, and I had a lot of situations where I needed to go to town council, and town council and you, I'm guessing, sometimes took on with the police officers what the police chief's decisions.
I'm sorry, can you repeat the question?
Sure. So as town council,
Yeah.
do you represent police chiefs?
In litigation, not so much in employment issues.
So not in disciplinary matters?
Right, no, I did not represent them in disciplinary matters, we had labor attorneys.
Sometimes the town's position would get out with maybe the officer.
That is correct,
You have
yes.
to make a determination whether or not it's covered.
Coverage in, there are odds in terms of like you say, a disciplinary matter. Sometimes our attorneys were used as hearing officers in those matters and did determine whether, discipline was warranted. When you say coverage, do you mean,
Well, it's an allegation in 1983 action, and the allegation is the cop punched somebody in the face. Is there insurance coverage for that?
yes,
Is the company going to pay you
yes.
automatically? Even if it's just an intentional act by the police officer?
So the only time you would determine that there might not be insurance coverage, you would have to go to the end of the trial, and there would need to be a determination that this was beyond the scope of their employment. If A, it wasn't unintentional, and B, it wasn't like in the heat of an arrest, where the arrestee was, they came to fisticuffs, that would result in a elimination of coverage.
We'll try not to defend those. Day one.
Yes.
And I know Council Casey, Council, I know was talking about continuing to, he wants liberal construction of that. My issue has been in the medical malpractice. And I know before the judge, and I told him before the judge recently, he said, we need an expedited trial. My guy, quadriplegic, he's been bedridden for 2.5 years. The suit is now 3.5 years old. And the defense lawyers inevitably stand up and say, I'm sorry, but Mr. Juneville is the only guy that can try the case. He's not available for the next 23 months. And I see that happen repeatedly. I think it's a huge flaw in our system. I want to know what your opinion is on what you're going to do with your bench.
That as I try to set forth with Council Ionella, I want to take a reasonable approach. What you just explained to me is not, in my view, reasonable. It is not reasonable to say, I want to put this up for 2 years when it's already been going on for 3.5.
What about the argument that he's the only guy that can try the case? He's just not available, and that's it. I mean, would you say to find somebody else to try the case? You have 30 lawyers in your firm? This is the day.
What I call, something like that. I would say, he took the case, this is his case, he needs to be defending the case.
And he's gonna say, listen, look at my trial schedule, Judge, so I'm sure right now, I'm 18 months out, I just don't have a date for you. At what point do you say, listen, find somebody else to try the case?
Exactly. The reasoning being, you knew about this 18 months trials for, trial dates aren't set like a week in advance. Civil court, they're set months in advance. I know, it's cognizant of the schedule.
Yeah, I appreciate that, like I said, I have a case right now, it's probably gonna be tried 6 years, it's gonna be a 6 year. Mark from when he was referred on medical. And that guy since died, no, it's my argument, the guy's going to die. The defense kind of wants him to die, and it cuts off the damages, and the judge said, well, I don't think that's fair. I said, well, I do. I think it's a fair argument, and then the guy died. So we're gonna try the case with this case. I just see that over and over and over again, with the medical malpractice defense lawyer, the with interest, because I refer to a helicopter, and I didn't know that the town could, I mean, he has a huge piece of land, but, so tell me, are there any restrictions on what a town can do to regulate the helipads?
No,
They can
it's
ban
the
them?
same as getting man.
Really?
It's under their zoning authority, just like getting man.
Wow, oh, that's interesting.
And Rockford.
But, first of all, let me say that when I first heard about you and your application, I'm like, well, I've been on the light side of experience for 15, 16 years. But then I found out you were town council and, police chief, cop for 30 years. The stuff that you dealt with, I mean, 15 years being town council is like 30 years of, 40 years of any kind of practice, because, just the depth and everyday decisions that you guys deal with is amazing. So I thank you for your service. After I finished my clerkship, I interviewed at KP. I think I got a job offer, but if I did, I couldn't afford to do it anyway. It was a decrease from being a cop. So I thank you for your service, because I know when you do municipal law, you're not getting rich, and it's public service. You're doing it for the back. And I read, and I heard I missed, your first witness, but, you taught at the MPI, and you worked, with police officers.
Yes, that is correct.
What was the class that you taught at MPI?
In Fourth Amendment law, search and seizure, and also excessive force.
And how many cases did you try? Were they state cases or federal cases?
My trials.
Yeah.
So altogether, I had 25 trials. My application actually says 24. It is 25. They were both in the U.S. District Court and the Superior Court, and one in the Land Court. 13 of those were jury trials. The rest were non-jury. They were in counties. The Superior Court cases were in counties throughout the state.
What was the average length of trial?
The average length of trial in the federal were 5 days or longer, and Superior Court 3 days.
Well, I am very impressed with your resume and conversations. I think you're gonna make that a really good judge. Councilor Hurley.
Councilor Jubal asked me to take over
There you go.
and slow. And tell me I was next thing. I apologize for being late, but somehow or other, I ended up on 93 North. And ended up going to, I go to Summerville, go by the straps, and handicap. So I ended up going that. It was a long road. But we talked over the weekend. And many of the judges who come before us for approval have a broad background. And I remember wherever I was, seeing a sign for this lawyer who did divorce, criminal law, court cases, and real estate. That's the way the practice used to be. And I understand how there's a lot more specificity. My father's a lawyer for 50 years. He wanted nothing to do with anything else. So he would refer the rest of the law table on. And he said, handle it, handle it, handle it, handle it. Including one bankruptcy, which I found to be as bad as, in some instances, the emotional aspect of somebody losing a loved one. So I never did one of those. I never did a court again, because you should go there, one case, and you sit there all day, it's a waste. But I did enjoy going to court. I did enjoy doing criminal cases. I got to sit second chair on some other cases with my father. Great experience. I did divorces, which I felt I was able to do and do well. And no matter what, my father and I came to the conclusion that the best way to do the best for your client is not necessarily to have a huge number of trials. You can settle things out. my concern with your background, and, you know, if somebody said, who's a great municipal lawyer? I would say, yeah, no, hands down. My concern, however, is in Superior Court, you're dealing with people who have been victimized criminally. So they don't have any background or judgment. Most of the time when you have somebody come here, they've got experience as a former ADA, they've got experience as an ADA and a defense bar. And quite frankly, I am not concerned about civil as much as I am criminal. I'm a little here that's been a judge for 20 years. I know what it's like to have people come before you. And when I heard about that district court judge that let someone go who did rape and got caught at, and let them go for a ridiculously low bail, my blood boils. So I'm going to give you a couple of, for instances. And you said you sat in the district court and you hear things. You sat waiting, you know, for a trial. Sitting there watching is like me watching a farm, a golf course. I can watch them, but I'm never going to be able to hit a golf ball. And I can attest to that. For the years I played golf. The point I have is, you've got a case before you. You were aware of the fact that the district court fails to get appealed to the Superior Court?
Yes,
How did you come to know that?
2 ways. When my mother served on the Superior Court, I remember her talking about the bail reviews that she did. And also, as you mentioned, during my practice, some of the courts combined criminal and civil sessions. So when I was waiting for my case, I saw bail reviews being handled in the session.
All right, so you've got somebody who has a prior record, broke into this girl's apartment, raped her, and left his wallet on the floor in the apartment. The defense attorney says, my client is presumed not guilty. He doesn't have money to post for bail of any kind. And the prosecutor basically goes into some more detail. So the prosecutor is asking that this person be held without bail or on high bail of $100,000. The defense attorney saying, well, no, you know, you've got to consider whether they're not going to return the responsibilities that falls on his record. But he does have a record that includes a history for assault batteries, all right, larcenies, whatever. What are you gonna do? What bail would you post?
Well, I asked, the prosecutor has asked for a dangerousness hearing under 58.
All right,
And then all those things that you talked about that go to his dangerousness to society, as opposed to whether he is likely to appear in court, can be considered and evaluated in terms of whether there should be any bail or high bail.
all right. Let's say that the victim is reluctant to come into court to testify.
At the dangerousness hearing?
Yes. She's mentally and emotionally shattered.
I don't think that the victim needs to testify in order to make a finding by clear and convincing evidence, which is the standard under the statute, that the defendant cannot be released without posing a danger to either her or society.
Okay, so he says, all right, Your Honor, then I ask the defendant to be held for 3 days so that I can take my witnesses to the dangerousness hearing. I move.
Who asked for the 3 days, the defendant or the prosecutor?
Prosecutor.
The prosecutor asked for 3 days. They're under 58A, I believe, I mean, that can be done. I'm trying to remember whether it's a probable cause standard or a convincing evidence standard. But you until the actual hearing.
All right, so they have the hearing, you find that there is overwhelming evidence by the testimony of the police officers. So you find he's dangerous, you pull him. So you're back in that session, time's expired, in which he can be held on a dangerousness basis. What do you do then?
So,
Prosecutor comes in and asks bail.
so the 180 days has expired, in 6 months, and now the prosecutor comes in and asks for what? Asks for bail again, to be held or for bail?
To be held on bail.
Okay, the statute says it can only be held for 180 days as a result of the dangerousness hearing. So I think at that point, the statute requires that we have a hearing as to how much bail should be set for the police.
So prosecutor's asking you to hold him on $100,000 bail. That's what he says, I'm court appointed, he's got money, he didn't have a job for 3 months.
So the SJC has said recently in Randy that a defendant's ability to pay must be considered when setting bail. However, bail can be set at an amount higher than the defendant can afford when appropriate findings are made by the judge. If the circumstances are such that it warrants imposition of bail more than the defendant.
And I'm asking you, what would you set bail at? You're the judge of the case.
The prosecutors asked for 100,000, and what does the defense attorney want?
Wants him to be released on the bracelet.
What are the, how likely is he to appear in court? You know, does he have jobs and family? If you say, I'm sorry, you told me what the crime was, but I don't remember.
Great.
Okay, so very long, he's facing a very long sentence. Did you say he has records of default?
No.
Okay, no default?
He has prior records.
Okay, but no defaults.
They
Then
show a propensity for violence.
the state has lost its right to have him held because the 180 days has expired, so he can't be held. And you're asking me what bail to impose.
That's
And Brent, the SJC, says that absent a dangerousness hearing, you cannot use the danger a defendant may pose to society as a factor in setting bail, much as I may want to. The SJC was very explicit on that. In the absence of a dangerous hearing, the issue is whether the defendant is likely to appear for trial. So then I look at all the factors that determine, that go to whether he is likely to show up again.
what are the factors?
Factors are, he's had a criminal record, but he always shows up. And that's balancing in his favor. Balancing against it is that he's facing a long penalty, long imprisonment if he is convicted. I'd be interested in knowing in his prior record, did he show up when he was facing long prison time? Previously.
Larcenies, assault batteries, not
So-
felonies, not
Yes, not.
indecent assault battery, not assault with intent to rape. Okay,
No. He was not in the situation where he is now, where he's facing a long jail. I would take, the court says you are to consider whether there are family ties, employment, issues that go to show whether he is going to show up or not.
Three months.
Is an employee.
3 months.
There are factors weighing against the likelihood of him showing up. There are factors in favor of him showing up. I am unlikely to say a bracelet is sufficient. Bail would be set. Would be set at 100,000. Don't know if it'll go that high.
Defense attorney says, doesn't matter if it's 100,000 or $100.
But I can set it higher than he can afford if I make the findings that
Right.
warrant why. He
So why
needs a
would-
reason to come, he needs a reason to come back. He can-
He's got a rich uncle post $100,000, $1,000, or $25,000. All right? Or you had a drug dealer who was caught with, I don't understand. what would you say is a bail, a suitable bail in that case?
This is not a bail review, correct? Because I'm in the Superior Court, so I would also be interested in finding out what the district court.
Mr. Court, Ellen, on $500,000.
$500,000 sounds like dangerousness was taken into account, which it can't be because the 180 days expired. It wouldn't be 500,000, like I said earlier, it might not be 100,000.
The fact of the matter is, the district court didn't post bail. I just made up a number to see what to do with it. The fact of the matter is, they would deal with the dangerousness hearing. It is the district court that would keep him, okay, held because he would be arraigned in district court. All right? They would ask for the dangerousness hearing, as opposed to someone who's indicted on a crime that goes straight to Superior Court. And then you have a bail review. All right? But I just remember, what I'm trying to get at is, okay, miraculously, the district attorney's office elects the guy the next day. So it's in your court. Okay?
And there has been a dangerousness hearing, or there has not been?
There was a dangerous.
Okay, and we're at the end of the
Now
180
he's
days.
been indicted. So he's before you.
On the offense for which he was held for 180 days.
Right.
180 days has expired, so the judge cannot take into consideration his dangerousness to society. It has to be based on whether he was likely to appear. And that evaluation is made on the factors, most of them set forth in Brandon, as to whether he is likely to appear or not.
And what would you, as the judge, sitting on the bail hearing, set for bail?
I can't give you a number at this point. I
Because it has been there or done it,
that is correct.
as either a prosecutor or defense counsel.
Correct.
Fair?
Absolutely.
Okay. So let's talk about the, aside from the federal cases. All right, trials. How many Superior Court cases have you actually tried?
Yeah, 7 jury, and then a number of, well, all my non-jury cases were Superior Court except for 1. So there would be 11 non-jury and 7 jury.
And that the 7 jury were all in Superior Court.
I heard it down, I want to make sure I'm correct. The 7 jury were all in Superior. Yes. Yes.
And how many jury trials have you done in the last 5 years?
3.
And where were they?
Suffolk Superior, Bristol Superior, Norfolk Superior.
And how long did those cases last?
One lasted 4 days. One lasted 3 days and the jury went out on the 4th day. And one lasted just 2 days.
All right. Now, let's talk about what you said about the judge happening. All right. I heard I was here for the last 4 Supreme Court justices. They all said it would be malpractice. Not
It would be malpractice not to judge.
So, basically, effective assistance counsel would be something that might go up to Supreme Court, no one else would do. But, the thing about the continuances because Sundays, my father was in 5 different courts. Superior in Hampshire, Superior in Hamden, Chief District Court, Hoyle District Court, and then something in the federal court. And until I got there, he had to do it all. And what would you do in a situation you had 2 bar advocates who were supposed to be in your court? And they both didn't show up. And their excuse was they got stuck in the snowbank. And they didn't show up till the next day. And this was back before the age of cell phones. All right? And the judge, in this case was in the district court, cited them for contempt. So they came down to see my father. And there was